Greetings. Right now I'm going to talk about sources of law, and specifically in the U.S., sources of law. So let's get started. U.S., we have many different sources of law, and there are certain priorities for each of those sources of law. We're going to start with the U.S. Constitution. That is the preeminent source of laws in the U.S. If any other laws conflict with the U.S. Constitution, those laws will be stricken down. The U.S. Constitution cannot be easily amended. It has to be approved by the states. Any amendment has to be approved by the states in Congress. So it's very infrequent that the U.S. Constitution is amended. Next, in order of priority, are federal statutes. Federal statutes are adopted based on the constitutional grant of certain enumerated powers to the federal government. Now, the federal government does have a broad category of powers, but in general, the federal government has those enumerated powers that are listed in the Constitution, and federal statutes that are adopted under that power have nearly the highest priority. Next in order of priority are federal regulations. As you know, there are many administrative agencies that pass regulations that have an impact, especially on business conduct. Examples would include the Food and Drug Administration and the Federal Trade Commission. Those administrative agency rules are called regulations, and those regulations have the force and effect of statutes. So although I've listed the regulations under federal statutes, the regulations actually have the same impact of statutes on business conduct. The reason I listed federal regulations underneath is because the agencies can only act based on the power given to them by Congress. And Congress gives those powers through enabling statutes. But otherwise, in terms of just everyday powers, the administrative agency regulations are almost equivalent to federal statutes. Note that next in order of priority are state constitutions. Now, state constitutions, every state has its own constitution. If the state constitutional provisions conflict with federal regulations, federal statutes, or the U.S. Constitution, those constitutional provisions are not enforceable. In California, we adopt a lot of propositions that typically are amendments to the state constitution. Sometimes those propositions are challenged as being in violation of the U.S. Constitution. And if they do violate the U.S. Constitution, then those propositions rather, are not enforceable. Underneath state constitutions, we have state statutes. Those state statutes are adopted based on the police powers of the state, and those police powers are the powers to pass laws that protect the safety and welfare of the citizens of the state. Those are all the powers that are left over after the federal government passes laws in the enumerated powers. State agencies also pass state regulations. There are state administrative agencies. An example in California would be Cal-OSHA. That is the Occupational Safety and Health Administration for the state of California. Though that agency passes regulations, those regulations are roughly equivalent to state statutes as long as the agency is acting within its powers given to it by the state. And then we also have local ordinances. So cities and counties pass their own regulations that apply, or their own enacted laws that apply, and those can vary from county to county and city to city. All of these are what we call enacted laws. And I'm going to just put an E here for enacted laws. Enacted laws are laws that are passed by some governmental body. Note that I've included treaties in a separate category by itself. Treaties are contracts that the government makes, the U.S. government makes with other governments, and they have a high priority. Underneath all of these enacted laws, we have the common law. And the common law is what we also call judge-made law. So those are laws that are interpretations that judges make to resolve disputes between parties. The common law applies only if there are no enacted laws. So, if a judge interprets an enacted law, or there is an enacted law, the judge would just interpret the enacted law. If there are no enacted laws, so a case involves something where Congress or the state legislature or the city has not passed a law about it, then the common law applies and a judge looks at previously decided cases, or what we call precedent, to make the decision. That is consistent with the principle of stare decisis, which is a principle that says that let the decision stand. In order to promote predictability and flexibility, once a decision is made within a jurisdiction, then normally the court is bound by that decision. It is a little more complicated than that because different common law, there's no federal common law. Each state has its own common law. And so we have things called binding precedent versus just advisory precedent. But this is just a general overview, so as you're reading, you can kind of understand what these concepts mean. We also have equity. And equity are non-monetary remedies that are designed to remedy an injustice. When someone asks for an equitable remedy, they're really saying that the legal remedies, that is money damages, are inadequate to resolve the situation. So someone who's asking for an equitable remedy is asking for something like, will the court grant an injunction to stop someone from doing something? Or will the court grant specific performance and require that a party fulfill the terms of a contract? So again, this is an overview. As you read, you can keep these concepts in mind.